Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator of the Law Office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. I'm Leanne Lyon, and today we are talking about how DCFS appeals work in Illinois and what parents can do if they receive an indicated finding. Hello, Fedor. It's good to see you again.
Hello, Leanne.
Fedor, when someone receives an indicated finding from DCFS, what does that actually mean under Illinois law, and how serious is it for a parent?
Good question, as always. Well, let's talk about DCFS a little bit. So DCFS is the Department of Children and Family Services. This is an administrative agency, and such agencies exist all over the United States. But we're talking about the state of Illinois, of course, and DCFS in the state of Illinois was originally designed to protect children from abuse, neglect, and other things. DCFS also is involved in licensing daycare facilities and some other things. But for the purposes of this conversation, we talk about DCFS and their indications. So DCFS operates on several levels. And I'll talk a little bit about procedure, just so we understand how we get to this indication process. And it's different. So DCFS indication is not as indictment in criminal law. Indictment in criminal law, that means that you could be found guilty of a criminal act. Even if there is a criminal act, you can, and usually that's exactly what happens. You indict it in criminal law, but you also indicate it in DCFS. So indication in DCFS usually starts by somebody making a complaint. In the recent years, complaints coming from school most of the time, school, hospitals, and police. Every time when you call police due to domestic violence or anything like that, even if children are involved, police will always call DCFS just to make sure that everything is okay in the household. Once the detective for DCFS or child caseworker is called, they have 60 days from the day of the complaint until they send you a letter indicating that if you indicated or not indicated. Within the 60 days, this DCFS worker or caseworker will come to your house, will, based on the allegations, will talk to the witnesses, talk to school, things like that. You do need to cooperate with the detective from DCFS, because the DCFS caseworkers, they will always contact the police. They will be in touch with the police, and if you're not cooperating, if you're not allowed to give the child, to let them see the child or talk to the child, they can call the police or escalate this case to the state's attorney. There is one thing that when I talk about DCFS, I always mention it. You have to be extremely careful. You do have to cooperate. You do need to cooperate with DCFS. You do. You can say no. You cannot. You may not open them a door, but it's highly advised to cooperate with DCFS. At the same time, you have to be very cautious. If DCFS takes your child, and if the child enters DCFS investigator car, you lost your child. It's called protective custody. And if the DCFS drives away with your child in the car, you have to go through court to get your child back. So you have to be very cautious what is being investigated, what they're about, and things like that. So once you get this letter of indication, you have some time to appeal it. There are two ways to appeal it. One is you can file appeal and ask for the hearing within 30 days. This kind of escalated request. And the other one is the normal request that you can file within 90 days. So when you get indicated by DCFS, remember that it's burden on the DCFS by preponderance of the evidence, not by any reasonable doubt as in criminal law, but by preponderance of the evidence. Preponderance of the evidence means 51%. That's what they have to prove, that there is some kind of abuse, neglect going on in your household towards the child. Once you get this letter of indication, you usually get 5 years of supervision. So supervision for the purposes of DCFS for most people doesn't really matter. If you have a child and things happen sometimes, you didn't see how something happened, child fell, or child is missing but he went to your neighbor's house, minor things. You could be indicated even for that, for failure to supervise. It's going to stay on your record for 5 years, but nobody's going to see this record. So 5 years of supervision, it's really nothing for most people. However, if you work in daycares, if you're a nurse or you work at school, you might lose your license or you could be fired. Only for people who work with kids or working in the hospital are directly affected by the DCFS finding. And that's when you have this 30 days right to appeal, because this is your job that you can lose. And your employer probably usually running your background check to make sure that everything is clear. So for this purpose, you can file an appeal and you're going to get a hearing within 30 days. Everybody else gets a hearing within about 90 days or so. And then during the hearing, again, it's the department's responsibility to prove by preponderance of the evidence that the indication was correct. And that's why I'm saying it's all on different levels, because first you work with a caseworker, then there's a supervisor, and then it's administrative law judge that conducts the hearing. It's usually done by WebEx. And that's when the DCFS carries the burden of proof. So they will call as witnesses any witnesses who saw an incident. They're going to call the supervisor. They're going to call the caseworker. They're going to call a police officer if needed, things like that. And then later you're going to get a decision. Either your record is expunged. Expungement means that nothing happened. Or your request for appeal is denied, and that means that you still indicated. So if you file for an appeal and you go through this whole process and you lost at the end of the day, don't worry, because you're in the same situation as before the appeal. So nothing bad's going to happen. It's not going to be worse than it was before, but at least you have a shot, to prove and show that nothing bad happened to your child. And there can be a number of examples that I can come up with when you can win the hearing. And I personally, we handle about 3 hearings per week like that. And sometimes, abuse and neglect could be very much obvious, and sometimes it can be explained. So it depends on a particular statute. But even if you lose your appeal, your situation is not going to change. Final point on the process, that let's say that you got indicated, you went through the appeal process, you lost, and you have 5 years of supervision. Now, what happens if another DCFS case happens within this 5 years? Well, now you're in trouble. If you are still in supervision and there is another report of some kind of child abuse and neglect or alleged abuse and neglect, now you violated your previous supervision and you have another case. So you have 2 cases now. Most likely, these cases end up with the state's attorney, with the question if the child has to be removed from the household and if the child children has to be placed with a foster parent.
Have you handled a case where an indicated finding was successfully overturned, and what made the difference in that appeal?
I have multiple cases like that. Most recently, we had a case where it was a domestic violence situation between a husband and a wife, but the children were in a different room. And remember what I told you before, If the wife called the police. If police comes, they will call DCFS. So if children didn't see the father and the mother actually fight, if the children didn't see any broken property like broken chairs, holes in the wall, broken glass, things like that, you can get away with that if this is your first offense and if nobody was hospitalized, anything like that. Now, at the very beginning, I said that criminal law and DCFS go hand in hand, and that's also a very important thing for me to mention. When police arrives for a domestic violence dispute, it's likely that somebody will get arrested. So you cannot go through DCFS process until your criminal case is resolved. And here's why. Remember about the burden of proof. The criminal law, beyond reasonable doubt, 100% guilt. DCFS, preponderance of the evidence, 51%. If you go to trial with DCFS or criminal law, you have to testify under oath, and everything you say is subject to perjury. So you have to say the truth. And both of these testimonies can be used in both courts against each other. So if you go through DCFS first, the prosecutor can use this transcript later to convict you in a criminal case. So that's why criminal case goes first. You have to resolve your criminal case first. And if you found guilty, most likely you'll be denied your appeal in the DCFS case. If you found not guilty, then you might, again, it's not a guarantee, but you have a very good chance to win the DCFS case. Another case that I just recently handled, the DCFS was called for abuse and neglect of a child. And it's an autistic kid who went to school and told his friends that he wants to kill himself. He's a 12-year-old boy. So obviously school reacted and they called DCFS, they called the parents, they called the police. So when DCFS arrived at the household, they did not find any abuse towards the child. But what's interesting in that case was that they indicated the parents because the caseworker said that the house was a mess. So what started as a suicide thoughts tendency came as indication that there's a danger to the child because the house is not clean, and the kid was afraid to invite his friends over, and because he was autistic, couldn't invite the friends. He had this suicidal thoughts because he was kind of a stranger to school. So he was all by himself and he didn't really have friends. So in that case, the indication was overturned. We won the appeal. Parents cleaned the house, and hopefully the family is well and nothing else is going on. But my last example, also, it's always difficult to do cases when there's alleged child abuse, and indications usually goes with what the parents did in order to prevent this abuse if it comes from somebody else, or when we talk about suicidal tendencies. So this case was about a girl. So it's a family from Iran. They lived in United States for extended period of time, for about 15, 16 years. And the daughter didn't know any other life. And she was raised in the United States, and she was in her last high school year. And the parents told her that as soon as she graduates from high school, they are moving back to their country because according to their traditions, now she has to get married, so on and so forth. And she didn't want to go. She didn't want to go because she didn't want to leave the United States. She wanted to stay here. Her friends are here. She didn't know any other life. So she actually attempted to kill herself by going to the garage, turning on the car, and closing the garage. She was saved, but however, the parents got indicated. The parents were indicated, but what's interesting, they were indicated not for what led towards the girl having the suicidal tendencies, but what they did afterwards. So the caseworker in that case didn't like that the parents didn't go to a psychiatrist right away, didn't do some other steps in order to make sure that nothing like that will happen in the future. The parents obviously are for different culture, different religion, and that religion prevents them from doing certain things or going to seek help through doctors, or they don't believe in, they didn't believe in any help that can be provided to their daughter, but they did something else. So they it's not like they neglected her. They spoke to her. They had a family gathering and things of that nature, and they ended up staying in the United States. They didn't go. So initially, there was an indication, but because of the steps that they took, and that they didn't leave the country, and they actually put the daughter's interest ahead of what they thought they should have done, we were able to overturn the indication, and the record was expunged. So that case was won.
Just briefly, as we're finishing up here today, if someone's listening and they just received notice from DCFS and feels overwhelmed, what step or steps can they take immediately to protect their rights and their relationship with their child?
It's completely understandable that people would feel overwhelmed. When an agency sends you a notice that there's some kind of issue with your child. Sometimes, by the way, parents don't even know that, because this information might come from school. So school calls DCFS, DCFS calls parents. That's how parents find out that there is an issue. You need to work with the DCFS caseworker. There is no need to be defensive at all. There is no need not to answer the call. You need to cooperate and find out what is the issue. Absolutely talk to your child. Maybe, and do not, again, from my experience, just find out, get information. At that moment, you cannot blame anybody, especially your child. And remember, during the hearings, the child is never a witness. Everything that the child tells DCFS will be admitted as truth, and you cannot cross-examine a child. But finding information, finding the cause, getting to the root of the matter is very important. You can show it to the caseworker that you're trying to figure it out. And if the allegation is not as serious, I'm sure you can figure it out, and you can get a letter saying that you're not indicated. That happens all the time. Indications happens only when, again, by the preponderance of the evidence. So the DCFS just want to play it safe that maybe something is going on. But getting to the root of the matter and to the cause is the most important thing for you to do.
Well, that is it for today's episode of the Family Law Frontline. If you've received an indicated finding from DCFS and need to understand your options under Illinois law, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for listening, and be sure to give a review, and subscribe to the show so you catch the next episode, and share this episode with someone who needs to hear it. Thank you, Fedor.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.